Mr. Semick.
My lord. Dicey Rule 51, the judge in paragraph 43 of his judgment in core bundle A91 said that he thought that Rule 51 was significant. You all should see what he says. He assumed, he said, for the purpose of ground one, the judgment wasn't impeachable.
So sorry, which paragraph?
43, my lord, A91. If your lordships would also turn up the authorities bundle, please. Tab 42, page 808. 42, 808, which sets out Dicey Rule 51. And in the commentary at 14116, it's explained that during the 18th century, the first part of the 19th century, it was much debated whether a foreign judgment given by a court of competent jurisdiction could be re-examined on its merits when recognition or enforcement of that judgment was sought in England. And your lordship see what Lord Brougham said and what the Vice-Chancellor Page Wood said. And in due course, Rule 51 comes about to make it clear that the English court can't look into the merits of the foreign judgment, and that the foreign judgment is either impeachable under Rules 52 to 55, or it's not, and it's either final or conclusive. And if it is final and conclusive on the merits, and if it isn't impeachable, then it's conclusive as to any matter thereby adjudicated upon and can't be impeached for any error. So, first of all, Rule 51 is concerned, therefore, with the extent of examination by the English court of a foreign judgment in the circumstances described in Dicey 14116. And it cannot be used, and it isn't the purpose, to circumvent Dicey Rule 45. That's the first point, and that's the first reason why the judge is wrong with respect. Secondly, one's got to look at what it is that's the primary point, what it is that the foreign court adjudicated. Because one thing is clear, what the foreign court did not adjudicate upon was to decide that as a matter of English law, there was a debt. And as my Lord Justice Popplewell said this morning, the claim originally was for damages, and then what one simply had as a result of the judgment was an adjudicative order, a dispositive order, that 2 billion Russian rubles were to be paid. So the judgment didn't adjudicate upon that. The judgment reached its various adjudications on the terms set out in that judgment, and the consequence was the money order. So for those two reasons, the judge is wrong. But there's a third reason, that it wasn't right in any event to assume against Mr. Drelle that the judgment was not impeachable under any of Rules 52 to 55 in any event, because one of the primary points, of course, in the hearing, a primary point in the hearing before the ICC judge, but also before the Mr. Justice Richards, was whether there was a triable issue, and I use that expression in the summary judgment sense, that the judgment was impeachable for fraud. So that's another reason why Rule 51, the reliance by the judge on that rule, and indeed my learned friend's reliance on it, is misconceived. My lords, those are the submissions on ground one. Can I now turn your lordship's leave to ground two? And your lordships will need to have, your lordships will put away for the moment the authorities bundle, please. We will go back to it shortly. And your lordships need to have open, please, the judgment at A94, core bundle A94. Because at paragraph, just about paragraph, about the collapse, just about paragraph 59, the judge has a heading, grounds 2, 4, 5 and 6, analysis. But then he had a heading after that, the approach to be followed on the various issues. Now, paragraph 60, in fact, through to 70, we don't need to be concerned with, save just to point out that the respondent was arguing that notwithstanding that all that had to be shown was a triable issue, that in fact the hearing before the ICC judge was for some reason a trial, and the judge rightly rejected that submission. And then at paragraph 71, there's a heading, the approach to be taken on appeal. And the judge at paragraph 71 records the fact that the parties were agreed it was a review and not a rehearing. And then he sets out at 72 the respondent's submission that since the proceedings before the judge were a trial, the Volpe and Volpe principles should apply. At 70, which is in other words to show that the judge was plainly wrong. And in paragraph 73 to 74 of the judgment, the judge rightly rejected that submission, not least because he had found that it wasn't a trial, obviously. And then at paragraph 76, the judge also rightly said that the approach that should be adopted by an appeal court should be that of an appeal court hearing an appeal against summary judgment. And importantly, the judge then said that the respondent's approach, as set out in, summarised in paragraph 72, which was, it was a trial below and therefore it's Volpe and Volpe, judge plainly wrong, is borne out by the judgment of Lord Justice Newey in Malik. So the respondent was using the dicta, or trying to use the dicta of Lord Justice Newey in Malik to support its submission, which the judge rejected that it was a trial and therefore was a different standard of review. And the judge at 77 repeated his rejection of the respondent's Volpe submission. And in 78, his lordship then referred to the then Chancellor's dicta in Creation Consumer case, but he referred to it in the context of the degree of respect, as he put it, that had to be shown to the first instance judge. And at 79, the judge then set out his approach, and there's no issue taken with 79 Roman 1. But at 79.2, he said that, by contrast, if neither of the others approach set out in 1 above are present, so that the challenge is purely to what he called an overall evaluative conclusion, I should show a high degree of deference to the judge's conclusion and not interfere with it unless I consider it wasn't open to the judge, the formulation adopted in Malik. So, again, the respondent was pushing Malik still in support of its previous submission. On this appeal, the respondent has abandoned its stance that Volpe applies and that what took place before ICC Judge Burton was a trial. And it now says in its skeleton argument at paragraph 61 that the judge was right to hold that he was required to show a high degree of deference and not interfere unless he was of view that what the respondent calls the evaluative conclusion wasn't open to the ICC judge. And in support of that submission, the respondent relies also on 2 Supreme Court cases, which we'll come to. But first I want to take your lordships to Malik, please. And that's at the authorities bundle at tab 36. And that was an appeal against summary judgment in relation to an outstanding loan. The defendant argued that the monies were not repayable on demand because of an agreement that they would only become so through their unanimous consent or in the event of a sale or some other liquidity event. And various grounds were raised, all of which were dismissed. And at paragraph 78 to 79, my lords, at page 753 of the bundle, Lord Justice Newey went on to consider, obiter, what the standard of review was for an appellate court in a case like this. And your lordships will see that at paragraph 79, the submission on behalf of the losing appellant was that there was a spectrum of respect which the appellate court should show to the decision of the lower court, depending on the nature of the decision of the lower court, which is challenged, and that such a case such as the one before the Court of Appeal then fell right at one end of the spectrum, such that in practice there was no discernible difference between a review and a rehearing. I'm just pausing there. That submission was plainly wrong, because CPR 5221, as your lordships well know, provides that every appeal will be limited to a review of the decision of the lower court, and that the unless a practice direction says otherwise, or the court considers that in the circumstances of the individual appeal would be in the interest of justice to hold a rehearing. Your lordships well know that. Lord Justice Newey then went on to say, appropriate respect should always be accorded to the decision of the lower court, and that requires the appellate court to show a degree of reticence. Now, in support of that proposition, his lordship referred to the Supreme Court decision of DB against the Chief Constable of Northern Ireland, which I'll show you lordships in a moment, in paragraph 80, that case, the dictum of Lord Kerr. And he then said what is said in the last 5 lines of 753, which your lordship see. The decision of a judge, at any rate in a case like this, that a defendant has no real prospect of successfully defending a claim, is an evaluative decision on the facts, not a pure point of law. I think we should only disturb his conclusion if it was one we were satisfied wasn't open to him. My lord, as expressed, the proposition that appropriate respect should always be accorded to the lower court's decision, whatever it may be and howsoever it may be arrived at, may be right, because there's a certain elasticity in the word appropriate. However, the conclusion, and that requires the appellate court to show a degree of reticence, requires some comment. And we would make the following points, my lords. First of all, the start point is, as I've said, Rule 5221. So the appeal court will allow an appeal where the decision of the lower court was wrong or unjust because of a serious procedural or other irregularity in the proceedings. So if on the review the appeal court is so satisfied, the appeal will be allowed. But secondly, and as the judge recognised, different approaches to seeing whether the lower court was wrong will apply depending on the nature of the hearing before the lower court. A trial is one thing, a summary judgment application is another. And thirdly, it's well and long established that in appeals against exercises of discretion, the approach is as set out by the then Chancellor in the Creation Consumer case, which we refer to in paragraph 35A of our skeleton. I'll show your lordships that now. We can put away Malik, and that's a bundle, Appeal Bundle, Authorities Bundle 27.
Just before you do,
Yeah.
so do you say the last sentence there of paragraph 79 is wrong?
Yes, I do say it's wrong, because that is to overly constrain the powers of review of the appeal court.
I mean, it depends what you mean by open to them. I mean, if, as I understand it, if a lower court judge goes wrong in law, he can be overturned. If it's an evaluative decision, but is approached by taking into account the wrong factors or failing to have regard to relevant factors, is that something that can be interfered with?
Yes, but before we come, we've got to be clear as to what we mean by an evaluative decision. I'm going to explain that in a moment to the lords, because one could have an evaluative decision made by a judge, which we will see in the 2 Supreme Court cases I'll show my lords. But also one has simply exercises of discretion. Obviously there's the case your lordship posited could be a simple point of law, but there are also exercises of discretion where the discretion will be interfered with, including if the judge took into account an irrelevant matter, applied the wrong principles.
Okay, but just distinguishing between the two, I mean, an evaluative decision could be, for example, a decision as to whether something is an abusive process. That's not a discretionary decision, it's an evaluative decision.
Yes.
Whereas a discretionary decision is, do I order X to pay costs, and if so, how much?
Correct.
They're two different types of decision.
Agreed. Both factors, whether the judge has taken account of immaterial matters or hasn't taken account of relevant matters, will also be pertinent to a critique of both types of decision. Yes.
Right. I mean, there are dozens of authorities which summarise the principles both for discretion and for evaluative assessments as being procedural irregularity or unfairness, an error of principle, such as, for example, taking into account matters that shouldn't have been taken into account or vice versa, or so far out with the ambit of reasonable disagreement that it can be described as obviously wrong.
Yes.
You could have brought, I should think, at least
Well,
2 dozen cases in which that formulation
I agreed.
has been applied. And your criticism of the judge in this case, as I understand, is he didn't say the only criterion I'm applying is obviously wrong. He said I've got 2 points of principle to decide, mini trial and the other one.
Yep.
As I understand it, your criticism is those weren't the only errors of principle that he should have been addressing in the judgment of
That is right.
the district judge. Is
That is
have
right.
I got it?
That is right. And 79.2, he then set himself a bar which is not supported by authority. There is no authority which suggests that, at least in the sort of case before the judge had to show a high degree of deference.
Well,
That's just not right.
putting the thing in the language of deference or reticence is or maybe thought not to be the test itself, but just a paraphrase of what one is doing in giving the findings of the lower court a status which is different from, well, we can start again. To talk about deference or reticence and degrees of deference or degrees of reticence seems to me to be moving away from the principle as it's always been laid down. One sees the language in the authorities, particularly in the context of interference with findings of fact, where the trial judge has had the benefit of seeing and hearing the witnesses, and that engages a separate, an additional principle.
Yeah.
But otherwise, are we really concerned with reticence and deference?
Well, I completely agree with every word that has fallen, say for the last 6 or 7, that has fallen from my Lord's lips. I couldn't agree more, and that's why 79.2 is so surprising. It doesn't help the debate. It doesn't help the inquiry for a judge to think he's got to show a high degree of deference to what is wrongly called evaluative findings of a lower court judge, because it suggests that he isn't approaching it in accordance with the test, which, as your Lordship rightly says, is set out in hundreds of authorities, which I could have, but obviously didn't.
Is it your submission that the lower court in this case was not involved in an evaluative assessment?
Yes, wasn't involved in an evaluative assessment.
Well,
I'll show you, Lordship.
I'll keep quiet now.
I mean, just
wait for you to persuade me of that.
Just as to the expression showing deference, I mean, that is quite commonly used in the context of tribunals. There's authority that where you're dealing with a specialist tribunal, a degree of deference is shown.
Yeah.
Maybe that language is being carried over.
Well, it's unfortunate that the judge, with respect, has expressed himself in this way, because obviously, if he'd expressed himself in the conventional way, which my Lord Justice Popplewell described, which frankly we all know, then one wouldn't be having this debate. But it is surprising to see, with respect, the judge express himself in the way he does in 79.2, having gone through the process of reasons why I took your Lordship through those paragraphs, which he has, in paragraph 71 and the like, and to rely not on the straightforward dicta of the Chancellor in Creation Consumer and all the other hundreds of cases, frankly, which set the point out, but instead to pick out 2 particular points in 79.1 and then refer to this high degree of deference, which is apt to confuse. The trouble is one isn't entirely clear what the judge really was doing with respect. But and I say that respectfully, my lords, so I'm not going to take your lordships to Creation Consumer because it's trite stuff. Your lordships know all of that. But in relation to evaluative decisions are normally, and certainly in relation to the authorities which are relied on by my learned friends, and also the Chief Constable Northern Ireland case, paragraph 80 of Lord Justice Kerr's opinion in that case, which is referred to by the judge. These are cases, and I'll show you, Lordship, briefly, where there is a genuinely evaluative decision, because what the judge is doing is making findings of fact, although there's no oral evidence. He's making findings of fact and then evaluating those findings of fact in the relevant, for the sake of argument, statutory context. That's miles away from the case that was before the judge on this appeal. Lords, can I show your Lordship briefly then the Chief Constable of the Police Service in Northern Ireland case, which my friends rely on, Appeal Bundle 31. That was an application for judicial review. So it's page 580. Application for judicial review in relation to parades in Northern Ireland, challenging the failure of the police service in Northern Ireland to give assurances that they take action to prevent the parade taking place. In the event the parades did take place, the police took no action until much later on. And Mr. Justice Tracy held on the evidence that the Chief Constable had failed in his duties and the applicant's Article 8 rights to respect for private and family life had been breached. Those were findings of fact made by the judge on the evidence. The Court of Appeal of Northern Ireland allowed the appeal, and it then went to the Supreme Court, who reinstated the judge. And if your Lordships go, please, first of all, to page 604, paragraph 70, that's where we see the appeal being allowed. And then, my Lords, at page 606, 78, review by an appellate court of findings at first instance. And your Lordships see in paragraph 78 that, again, what one is concerned with, the appellate court was there concerned with the review of findings made by a judge at first instance. 79 is referred to. And one looks at page 608 in the quotation from Lord Reed, which is cited. Page 608, you see references to, in fact, let's look at the bottom of 607, 3 lines up really. As the court has stated in different contexts, the trial on the merits should be the main event rather than a tryout on the road. For these reasons, review of factual findings under the clearly erroneous standard with its deference to the trier of fact is the rule, not the exception. And at 4, reference to the trial judge. And then at 80, the statements in all of these cases, and of course in McGrady itself, were made in relation to trials where oral evidence had been given. On one view, the situation is different, where factual findings and the inferences drawn from them are made on the basis of affidavit evidence and consideration of contemporaneous documents. But the vivid expression in Anderson that the first instance trial should be seen as the main event rather than a trial on the road has resonance even for a case which doesn't involve oral testimony. First instance judgment provides a template on which criticisms are focused. The assessment of factual issues by an appellate court can be a very different exercise in the appeal setting than during the trial. Impressions formed by a judge approaching the matter for the first time may be more reliable than a concentration on the inevitable attack on the validity of conclusions he or she has reached, which is a feature of an appeal founded on a challenge to factual findings. The case for reticence on the part of an appellate or the appellate court, while perhaps not as strong in a case where no oral evidence has been given, remains cogent. The present appeal, I consider the Court of Appeal should have evinced a greater reluctance in reversing the judge's findings than they appear to have done. So the dicta which are relied on by Lord Justice Newey in Malik are from an entirely different setting. Effectively, it's a trial, and with respect, they have no place in appeals of the type with which we're concerned with. And therefore, it's a distraction, and potentially a serious distraction, to start bringing in notions of deference and the like, particularly a high-degree one.
Okay. Yeah. Can I just talk around that for a moment?
Yeah.
I quite follow. This seems to be dealing with findings of fact, and
yeah.
there are authorities dealing with those.
Yeah.
But as my Lord says, there are also authorities dealing not only with exercises of discretion, but evaluative matters.
Yeah.
The one I've got in mind as an example is Sprint Room, where you'll find a summary of what the Court of Appeal said the principles were there. So in a sense, the real question is an appeal against a summary judgment decision an appeal against an evaluative decision? If it is, then who cares about whether it's about a trial or whatever? The principles that are familiar from challenges to evaluative decisions presumably apply. And likewise, in this context, and I assume that what we're really concerned with here is not the correctness of the judge's decision, but the correct, or Mr. Justice Richard's decision. We're concerned with the correctness of the original decision. And the question is, in assessing the correctness of that original decision, do we approach that on the basis that there was an evaluative assessment such that the Sprinkram type principles apply?
There was obviously some sort of assessment. There's got to be an assessment. And in fact, the word or the adjective evaluative may not actually add a great deal, because what the judge is meant to be doing is looking at the evidence in the correct way and then reaching a judgment. And the process of reaching that judgment is consideration, evaluation. One could think up lots.
But it is quite helpful, isn't it? Because a judge could look at the evidence and then find a fact. Just X happened or Y happened. I mean, that's a fact-finding question. The court could look at all the circumstances of the case, the evidence and everything else, and reach a discretionary decision as to whether to order X or Y, or costs being an example.
Yes.
But then sometimes the court has to determine whether a particular statutory test is met, of which summary judgment is one, genuine and substantial dispute is another. At least that's so well baked into bankruptcy and insolvency. And it's that evaluation of whether, on the evidence and the legal arguments, a particular test is met. That's what evaluation is.
Again, yes, that's why evaluation can perhaps mean slightly different things, because the evaluation, to see whether a particular threshold is met. So, for example, take children's cases. So in children's cases, I don't practice in that division, but from one of the authorities, children's cases, the court will make findings of fact, typically based on affidavit evidence, and then see whether a particular threshold, for example, under the Children's Act, is satisfied or not, and then go on to make a discretionary decision. And in trials, there are findings of fact. Of course, in this case, there were no findings of fact, and shouldn't have been findings of fact, because this was an application, effectively, summary judgment style application. The judge couldn't make findings of fact. The judge hadn't heard the witnesses. What the judge was concerned to do was to identify, like in a summary judgment application, whether there was a triable issue. The findings of fact would await, hopefully, the day when there would be a trial.
Well, you could find facts if there was no dispute on the evidence.
Agreed. And there is one instance in this case where the judge accepted, we'll come to it, something as read because it wasn't disputed by the other side.
Yeah, and then you could.
Well, it may be that this
and then you could, and here I tread very carefully because I've had my foot blown off before in this context. If the evidence in opposite, if the evidence, it's in the bundle, yeah. If the evidence is so inherently implausible that it can be disregarded without more, but that is a high hurdle.
Well, I'm going to respectfully correct the Lord, and because language here is important, it has to be manifestly incredible. Okay. That's the language. No, but it's in because in this case the judge used the word later on implausible. Didn't even go inherently implausible. He just said implausible. And of course, your lordship well knows one can think of something which is implausible, but which is not manifestly incredible. I mean, it's a fact. So, but it may be that this is a slightly sterile debate because the focus of ground two.
But that latter thing, whether it manifestly incredible or whatever that I was told that I ought to have applied. I mean, that's an evaluative decision, isn't it?
Yeah, I mean, it may be this word evaluative. I mean, evaluative. And the reason why I've been making these submissions to your lordships is because the cases that are cited but relied on by Lord Justice Newey and Mallock, the single case, the Northern Ireland case, and the two cases relied on by my learned friends, are not cases of the type with which we're faced with here. Those were cases where there were effectively trials. They were the main event, where the courts describe the process as findings of fact, and then evaluations based on those facts. If your lordships care to say that, that the ICC judge in this case was evaluating the evidence before her to see whether there was a triable issue, then I won't quarrel with that way of putting it. But she's still...
But do you quarrel with that being an evaluative assessment in the sense in which that term is used as analogous to a discretion and engaging the principles that we've just...
No, I do not.
I'm sorry. I thought earlier you'd said to me, this didn't involve me.
Oh, well, no, your lordship is right. Your lordship is right. Originally but I was understanding and using evaluation in the context of those cases, the Supreme Court cases, where there are findings of fact which are made.
No, I'm simply, for my part, I'm trying to get clear what your submission is, and I understand it to be that you accept that the principles which we've articulated, which are in dozens of cases, apply to the exercise that the first instance judge was undertaking in this case. Is that right?
Apply to what should have been Mr. Justice Richard's review of the first instance. Yes. Correct.
Sorry, apply to Mr. Justice
Richard's review of the ICC judge. Because the ICC judge was concerned to see was there a tribal issue.
Are we in this respect concerned with what Mr. Justice Richards thought? I mean, I'm not sure. I'm not evaluating his decision, but evaluating her decision.
Well, it's seeing where she went wrong in coming to the conclusion. I mean, ultimately, maybe one is dancing on the head of a pin. And
I'm conscious that you're going to use up a lot of time.
Because I want to get to the meat of it, which is really ground 3 and ground 4. Ground 2 arises because of the way the judge expressed himself in paragraph 79(2). I hope your lordships appreciate that I'm not. Our position is well, there's no disagreement, if I can respectfully put it this way, between what your lordships have said is the proper approach to exercises of discretion in this sort of context or appellate review. There's no disagreement. The disagreement on our part comes with the way the judge has expressed himself, and this because it may be that because the judge thought he had to show a high degree of deference and approach the matter in this narrow way to see whether the result, the finding, was open to the ICC judge, that caused him to adopt what we say is the fundamentally wrong way he went, which is covered by grounds 3 and ground 4. That may be an explanation of why he did what he did. On that basis, then, can I go into ground 3? Miss Żeglova. My lords, it is an irony of the judgment that the judge, having said that he should approach the ICC judge's conclusions, evaluative conclusions, that's paragraph 121 of the judgment, with a high degree of deference, it's an irony that he failed to do that in relation to the ICC judge's conclusions as to the import of the evidence of Ms. Żeglova. I'm going to come to what Ms. Żeglova said in her witness statement. But it is plain, as I'll show your lordships, that the ICC judge understood what the import of that evidence was, namely that the case had been predetermined, meaning that it wasn't tried with a judge like in this jurisdiction, without fear or favour, deciding the case in accordance with the law on the evidence alone, but rather, in the case of Mr. Drelle, that because GPN, effectively the Russian state, was driving the case against him, he stood no chance of winning in Russia. So what did the ICC judge find? If we can put away authorities but all other bundles and just please have open the core bundle and the ICC judge's judgment, which your lordships will find at, we take you directly to AB, A65, Lords, which is paragraph 115 of the judge's judgment, heading Ms. Jeglova's evidence. And what she says is it was Miss Lobanova, 5 lines up from the bottom, who said to have spoken to Mr. Goosejoe and returned saying it wasn't good news for Mr. Drelle. GPN was pushing the claim, and as such, a phrase we'll come back to, due to its powerful ties at the highest levels of the Russian state and consequent influence, Mr. Drelle would not be able to win the case. Would not be able to win the case. The last sentence, at a time when, that's to do with timing. I'll come back to that. I don't want to mention it now because that's wrong. I'll return to that. My lords, the colon, after the word Drelle, 4 lines up from the bottom of the page, shows that what the judge is doing is reporting her understanding of what Ms. Lobanova told Ms. Jegloova. And that's right. And that's plainly what the judge understood. My lords, then over the page at 116, that's the point about the timing, again, which is wrong. I'll come to that. And then 117, the judge says, court must consider Jeglova's witness statement in the context of the test I've held this court must apply. Her statement comprises evidence of the fact that her conversation with Lobanova took place. It's not evidence of the truth of what Lobanova is reported to have said. And it's not evidence of the accuracy or truth of what Lobanova said to learn from the conversation with Goosejoe. Pausing there, of course, it was evidence of what was said and was relied on as such, and entitled to be relied on. And then she says, and again, I'll come back to this in due course, it's double hearsay evidence as such, it's not cogent evidence, and so on, and then it only refers to the first Russian judgment and not the rest of it. And then, my lords, critically, a paragraph which Mr. Justice Richards did not refer to. 131, and it's 131, my lords, comes under the heading, if you should look at A66 first of all, comes under the heading State Influence Partial Proceedings. This is where the judge is looking at the expert evidence. And at 131, page A70, having discussed what Mr. Loff has said, the judge says this: the most I've seen is a keen interest by GPN's CEO to pursue Mr. Drelle via criminal proceedings. Anecdotal evidence that the Russian courts would be reluctant and or highly likely to rule against GPN, that's Loff. And then this, and hearsay evidence that the arbitrage proceedings were predetermined. But that is a reference to the hearsay evidence of Ms. Jegloova. And that is the judge herself understanding what the import of that evidence was. That the case had been, that the case was predetermined. And then and it's interesting because if one looks at paragraph 160,
I'm not sure. I'm obviously missing the punchline.
That was the punchline. That was the punchline. But it's not the first time that people have said that to me. Lord, the point is this: what the judge is doing here is drawing together strands to see whether there is a triable issue that the judgment's impeachable for fraud. And what she has done, she's already disposed of Mr. Kulkov's evidence, which is how the Russian proceedings were conducted. What she's now doing is summarising what she says she's heard from Mr. Loff, who is the, if you like, political expert. And she says that all she's seen first 2 lines, and it's the 3rd line, my lord. And she's saying what she's seen. Hearsay evidence. That's a reference to Jegloova. Hearsay evidence that the arbitrage proceedings were predetermined. Why do I show your lordship that? Because Mr. Justice Richards says that the judge didn't make that finding. That's why. Mr. Justice Richards says, oh no, all the judge found was the evidence wasn't sufficiently cogent, which is not what the judge says, and then says there were various gaps, and he then proceeds to fill in those gaps. But what one has here is the ICC judge herself referring to her understanding of evidence before her, which was that the arbitrage proceedings were predetermined. That's the punchline, because that is what Mr. Justice Richards doesn't refer to anywhere in his judgment, and that's what he misses. Because what he should have done is taken that as read, that's what the judge found, and then gone on to consider whether she was right to effectively discount that. That's the punchline. That's what's so critical about 131. And, my lord, in that context, if your lordships can just, earlier on, please, in the same bundle, look at what Mr. Justice Richards said in relation to this paragraph at page A106. The judge says, I don't agree with Mr. Drelle 131 represented the outcome of the mini-trial, rather than an examination of whether a triable issue was present. And then he says this, rather, 131 is an evaluative conclusion on the significance of Mr. Loft's evidence when put together with the other evidence she was shown. And that other evidence she was shown was Ms. Zheglova's evidence that the case had been predetermined. And that's how the ICC judge understood it. And then your lordships may be wondering, well, in that case, why is it that the ICC judge didn't find there was a triable issue? Well, we'll come to that in a moment. But this is precisely what, with respect to his lordship, Mr. Justice Richards missed, and which he didn't refer to, because what he should have done with respect is taken that as read, and then should have approached the issue as to whether the ICC judge was entitled then to discount that evidence that she from as in Zheglova's witness statement, hearsay evidence that the arbitrage proceedings were predetermined. And it's so the reason I show you lordships 116 is because Mr. Justice Richards recognises that that was evidence she was shown, rightly so, obviously. And then, my lords, 138, going back, please, to page A71. Again, the ICC judge says, beyond the hearsay evidence of Zheglova.
Sorry, you're back to, sorry, which
one? A71, my lord, paragraph 138, Roman 1, ICC judgment.
Sorry, going forward, sorry. Okay.
Sorry, going forwards.
Yep, sorry.
So, yes, back from 106, but going forwards from before. Because I'd shown my lord, Mr. Justice Richards' judgment.
Oh, sorry, yeah,
later.
okay.
Sorry, but we're now back. At 138, ICC judge, hearsay evidence of Ms. Zheglova, alleging the chairman of the court disclosed to a third party the outcome of the judge before it was released. Well, that's wrong on the facts, and I'll come back to that. Then various serious but anecdotal concerns. She then says, I've simply seen no evidence, and so on and so forth. And she makes the point that she hasn't seen such evidence in relation to all the courts. My lords, and then I should show your lordships also paragraph 21 in the judgment, and that is where what, that's at page A33, what the ICC judge is doing. Your lordship sees at paragraph 20, Mr. Davenport's counsel then for Mr. Drelle relies upon the flaws in the Russian judgments. 21, lordships see then 5 lines down. There is also evidence of Ms. Zheglova stating she was informed by a well-placed third party that the chairman of the commercial court had informed the third party the case against Drelle was predetermined. Now, to be fair, I can't say to your lordship whether that is a finding or whether it's simply repeating what Mr. Davenport submitted.
Yes, it's in the section recording the submissions.
That is right, and that's why I mentioned that to my lords, and that's why I make the submission. But the key paragraph is paragraph 131, which I showed your lordships. Now, my lords, let me turn to Ms. Zheglova's evidence, which your lordships will see in the supplemental bundle at begins at B124. We'll come to it in a moment, but can I make a few preliminary points to your lordships? First of all, this wasn't one of those cases, which I don't know if your lordships may have done this when your lordships were at the junior bar, when a defendant comes along and says they've heard from X or Y unidentified, from some unknown source, that something wrong has happened, and there's a vague witness statement with nothing you can really pin down. This isn't one of those cases. This is a case where a professional person has come along, made a witness statement with a statement of truth, and been specific in the evidence. And there was no suggestion that she was in some ways a partial witness or biased or anything like that. That's the first point. Lords, the second point is that this wasn't one of those cases where Miss Żeglowa's witness statement was produced at the 11th hour at the door of the court, thrust into the hands of the opponent, as it were. Not at all. There was plenty of time for the respondent to investigate matters if they wanted. Thirdly, which follows from the first point, she named all the relevant actors involved. So they could have been contacted if the respondent had wanted. And fourthly, the respondent did not require Ms. Żeglowa to be cross-examined. Now, there may be an agreement about that, but there was no requirement that she attend for cross-examination.
Was that a realistic possibility?
Well, yes, my lord, why not? If the respondents had said, we want her to be cross-examined, you might think it would cut across their point that there was no triable issue. But yes, why not?
We don't normally have cross-examination on disputed winding up petitions or bankruptcy petitions.
Which kind of goes to the point that it's the wrong forum anyway to deal with issues relating to the impeachability of foreign judgments.
Well, it goes, I mean, the theory is in relation to an ordinary disputed debt type case that you work out whether there's a real dispute. You don't hear witnesses on the point.
As in summary judgment applications.
Well, in that
it's said to be the same.
Fair enough, but I say that as to, in order to bolster a point as to what the judge should have done in relation to this particular evidence. Because in relation, for example, to some other cases, like Long and Farrow and Coyne, which your lordship will well remember from Kirieva, there's reference to witnesses not being summoned for cross-examination, and that being material consideration. That's why I mention it. But your lordship's right, that on summary judgment and those sorts of cases, you look at the affidavits, and what judges ought to do, as this court has said on many occasions, is to resist the siren call to decide the case themselves and simply see whether there's a triable issue or not. My lords, but before we just delve into Żeglowa, I come back to the central point, which I'm going to repeat, which is that the judge should have taken as the start point the ICC judge's own finding, call it that, understanding, conclusion, evaluation as to what Żeglowa's evidence was. And that is, as set out in 131, that the arbitrage proceedings at first instance were predetermined and therefore impeachable. My lords, if your lordships go, so first of all, at paragraphs, going to Żeglowa, page B125, background and experience, your lordships see there, she was employed as the finance director of ST, qualified accountant and auditor, a professional person. And then, my lords, at paragraph 73, page A20, she says this: in my personal view, and given my professional experience, the role of the chairman of a regional court, so that's Mr. Guschev, whom Ms. Labanova spoke to, has a decisive role in deciding major cases in Russia. The judges allocated to cases involving large companies, particularly state-owned companies as GPN, discuss with the chairman of the court such cases, and decisions are taken in consultation with the court. Pausing there, that is a startling state of affairs and repugnant to any lawyer or judge in this jurisdiction. My lords, pausing there, can your lordships keep the judicial finger at A20, but also turn to A99, please? This is paragraph 82.
Sorry, do you mean A99?
Well, it's paragraph 82 of Mr. Justice Richard's judgment.
Oh, I see, sorry.
Which is at A99. So I think, yeah, I hope I do. I hope that's the right page, because I've marked it up now.
Sorry, it's just that we had an A number in the supplemental bundle.
Sorry.
I've got my judgments loose, so if you could give me a paragraph number where
82,
you
my lord.
refer to the judgments, that would be helpful.
82, my lord, thank you. So, Mr. Justice Richards says this in 82. Mr. Goosechev wasn't the judge in the case. He was the chairman of the commercial court of the Yaroslavl region at the time. The judge, that's the ICC judge, didn't make detailed findings as to the role of the chairman. However, ST, respondent, has not taken issue with the following quote from 73 of Ms. Zhegleva's witness statement, on which Mr. Drelle relied in his skeleton argument, and I therefore accept that statement as accurate. That's the paragraph which I just showed your lordships. And we'll come back to that. That has particular resonance and relevance later to Zhegleva's evidence. But it is a startling statement. And then, my lords, at paragraph...
Sorry, can I just understand what you're saying about that? I'm looking at paragraph 73.
Yeah.
Are you saying that it's inherently what? Wrong, contrary to natural justice? I mean,
Yes, I do. The idea that someone who's not the trier of a case should discuss the case with the judge who's actually deciding it, and that person, not the trier of the case, should have a decisive role in deciding the case, is an outrage to justice. It is outrageous. That is exactly what I'm saying. And I don't shrink from it.
So to be clear, would you say that of itself and necessarily, regardless of anything else in this case, would be a basis for not recognising a Russian judgment?
Yes, I would.
every Russian judgment?
No, not every Russian judgment. In this particular, I'm not concerned with every Russian.
Or just judges cases involving large companies?
Well, cases involving state-owned companies such as GPN, which is what this case was. That of itself, I mean, I don't put my case just on that basis, as you know, but I do say that should give rise to a triable issue. Let me be, at the very least, and capable of rendering the judgment impeachable. Capable.
But that would mean every judgment of a Russian court in a case involving a large company, particularly a state-owned company, would be impeachable.
Well,
is that what that's actually saying?
Well, what it's saying is the practice, again, within the confines of this particular case, the practice is that judges, the chairman of the regional court, have a decisive role.
How does she know?
Well,
in my personal view, I mean, what does that mean?
What's her professional experience she's
Yes.
drawing on?
my lord, my lord, your lordships may quibble with that, but the point for present purposes is that the judge has taken that as accurate. Mr. Justice Richards has taken that as an accurate statement. He says in 82, and I'm entitled to pray that in aid. The judge says, ST hasn't taken issue with the following quote, and therefore I accept that statement as accurate. So I'm entitled, with respect to, make my submissions based on that, and I do. And so I don't pretend to make any wider submission than what is particularly than what is particular to this case, based on that particular.
We're sort of mixing and matching now. So you're saying Mr. Justice Richards has taken that because it isn't contradicted.
Yeah.
I suppose is this right? But where did ICC Judge Burton deal with it?
I don't think ICC Judge Burton did not. Well, if one goes to 131, one's got, which I've shown your lordship, a keen interest was how she put it, by GPN. That's I think a slightly different point. That's criminal proceedings.
Yeah.
Then 13. I don't think she does deal with it. Certainly not in the way, but it's accepted, as I say, by Mr. Justice Richard. I'll make clear, I'm not making submissions wider than this particular case, and my submissions are based on that statement, dictum, of Mr. Justice Richards in that paragraph. But your lordships know that I do not rest ground 3 on that. That is an added point. I rest ground 3 on the ICC judge's findings of what the Drelle evidence meant and why she rejected it. But that is, as it were, grist to the mill. Now, your lordships, as I say, your lordships may not like that. I put like in a broad judicial sense. But as I said, that's what Mr. Justice Richards has found, and that's what I'm entitled to rely on. My lords, then, cutting to the chase, going back, please, in a supplemental bundle to A20. At 75, Drelle says she contacted Miss Lubanova. 77, Lubanova is the general director of a very large audit firm. 78, knew that Lubanova would be acquainted with other professionals from the region. 79, she called Lubanova in January 2019 on her mobile. We agreed that Drelle would travel to Nizhny Novgorod, where we could meet there on about 26th of January, the day. At that day, Ms. Lubanova was to attend an auditing conference near the city. 80, she travels there on the 26th. They meet in a cafe. 81, she explains the situation to Ms. Lubanova, namely that Mr. Drelle had received a claim from the receiver, 4.4 billion rubles. I asked her if she can contact Mr. Guschev, the chairman of the court, and find out who's really behind this claim, as we're extremely confused in this situation. We thought that we were working with GPN towards the same goal, recovery from Mr. Motilev, who was the guarantor. 82, Lubanova said she'd go and make a few calls and let me know what she finds out. Therefore, she left the cafe and I stayed waiting for her. 83, she returned after approximately 1 hour. I understand she spoke with Mr. Guschev. Ms. Lubanova said things do not look well for Mr. Drelle. She said that GPN is pushing this claim forward. Given that GPN was behind the claim, which is understood to mean a very influential and powerful company working closely with the highest levels of the Russian state, we cannot win this case. She said that the decision would be judgment against Mr. Drelle for 2 billion rubles. And then 84, after this conversation, so what's being reported in 83 is a conversation between Lubanova and Guschev. Lubanova left the cafe and I reported this conversation to Mr. Drelle. I already told Drelle I'd be travelling to Nizhny Novgorod. And then 85, we decided that in spite of the negative outcome, which Mr. Guschev had described to Ms. Lubanova, pausing there, the negative outcome is the fact that he's going to go down for 2 billion rubles. That's the negative outcome. That we would still argue this case. On the same day, I returned to Yaroslavl. 86, as expected, due to my conversation with Tatiana Ms. Lubanova, the commercial court of the Yaroslavl region didn't consider properly Mr. Drelle's arguments related to the above. Instead, the Russian judge considered and accepted ST's and GPN's arguments without any hesitation, even if they were not presented in a derogatory manner. 87. On 24 April 2019, the court handed down a judgment to recover from Mr. Drelle 2 billion rubles in favour of the receiver, and these are the key words, just as Mr. Guschev had described to Ms. Lubanova on or around 26 January 2019. Therefore, I've no doubt that the outcome of the claim against Mr. Drelle was predetermined. Didn't matter what evidence and arguments we would bring forward, the court was bound to satisfy the claim of the receiver and indirectly GPN. This was clearly due to the influence and power that companies like GPN have over Russian court proceedings. Then 89 over the page, my lords, given my professional experience, I believe that the court clearly did not handle the matter in a fair manner. And in these words, and Mr. Drelle's court case was decided in advance, brackets, as it was confirmed to me, see below, obviously should be see above. So it's quite clear, we say, quite clear what the import of this evidence of Mr. Glover was. And then we can also look at it actually at 67, which is page A19.
Just as an innocent abroad, can I just ask you a question?
Yeah.
Why did Miss Seglova think that the Mr. Gustchev would agree to speak to Miss Lobanova about the case, or that was a proper thing to ask her to do?
Sorry, Bruce?
Just curious in the sense of
Yeah.
why did Miss Seglova think that it was appropriate to ask Miss Lobanova to speak to the chairman of the commercial court about the case that was pending?
No doubt, because of the view she expressed in paragraph 73. She wanted to find out what was going on.
No, but so it's not the same. It's not the same point, is it? Why do you suddenly think that the chairman of the regional court will suddenly start talking to some auditor who just happens to have his mobile phone number or whatever?
I don't know.
Not. Just he'll go.
The truth, I don't know, but that's what the evidence was, and that's the sort of question maybe that could be asked in cross-examination. But I don't know what the answer to it is. It's not suggested that this was made up.
No, but she also doesn't explain why she thought that if she asked, Miss Lobanova would contact Mr. Gustchev and find out what's going on.
Well, I mean, it's not for me to give evidence.
Okay.
Obviously,
Right.
there is
But
no evidence.
There is no evidence about that. We've got
No,
the report. Okay.
but maybe it's because Lobanova is what's said in 77 that she's big in the Nizhny Novgorod.
Well, it's 78. I knew that she'd be acquainted with other professionals from the region. That's as far as you can go, isn't it?
That's as far as I can go. But it's not, with respect, it's not, with all due respect to the Lord's question, it's not really. Well, anyway.
Okay.
I mean, but I don't know. And Lord Justice Popplewell has rightly said it's as far as I could go.
Yep.
And even that's not very far. Anyway, I was going to show you Lordship 67, I think, page A19, which was before, obviously, a paragraph before she gets into it. But we later discovered that she's teeing it up, as it were. GPN was indeed the moving force behind these proceedings against Mr. Drelle, and a judgment.
So where are you?
A19, para 67. A19, para 67.
Yeah.
We later discovered GPN was indeed the moving force, and a judgment against Drelle will be entered. To show you that. So, but the evidence is clear. Evidence is clear, and there isn't this analysis, or I should say conspicuous, frankly, by its absence, is an analysis of those paragraphs in the judgment of the judge with respect. Because when one looks at what is said by Ms. Zhiglova in the paragraphs which I showed your lordships, it's clear that what she's reporting, and it's clear that there is evidence from the conversation of Lobanova and Gustchev that the case is predetermined in the sense which I've mentioned. So then one has to ask oneself, well, why is it that the ICC judge, who in 131 correctly described the import of Zheglova's evidence, which is the case had been predetermined, why is it that she effectively discounted the evidence? So we have to go, we can put away the supplemental bundle, please, and go back to the core bundle, and it's, sorry, Yeah, the core bundle, and it's, my lord, it's page A66, paragraph 117. And what is said is, she said, it's not evident, we looked at this way, it's not evidence of the truth of what the Barnabas reported to have said, not evidence of the actual truth of what the Barnabas said to have learned from conversation with Goose. Pausing there, as I said, well, that's just a wrong and unfair way of putting it, because it was obviously tendered as evidence of the truth of those matters. But then she says this.
Can we just... Sorry, go on.
I mean, this is all phrased,
Yeah.
I think you say, as if it's accepting Mr. Phillips' then submission that this evidence was inadmissible under the Civil Evidence Act, because it starts with her statement comprises evidence of the fact that her conversation took place. That's exactly what you would say if you were treating it as inadmissible. It would be evidence of the fact of the conversation.
Exactly.
It's not evidence of the truth of what Ms. Lobanova is reported to have said. It's not just it's not credible or not to be accepted. It's not evidence in the case.
Yeah.
It's not evidence of the actual truth of what Ms. Lobanova is said to have learned from her conversation with Mr. Guschev.
Yeah.
It is double hearsay.
Just wrong.
So that certainly speaking for myself, looks to me as though that is the basis on which she has discounted the evidence entirely.
So there are two possible bases. Your Lordship is absolutely right in what your Lordship has said. It looks as though she's still got ringing in her ears a friend's submission, which, to be fair, on appeal he accepted was wrong.
Yes.
But then she goes on, does the ICC judge, to say, I think your Lordship's right, it's double hearsay evidence. As such, it's not cogent evidence. So the only reason given for it not being cogent is either because the judge has got ringing in her ears still the inadmissible submission. I can't recall whether that was withdrawn later by Maloney Friend. I can't recall at the moment. But in any event, even if it was, and it's just tethered to the previous sentence, it's double hearsay. It's wrong in any event. It's wrong in any event. So
What do you mean by wrong in any event?
well, because the fact that evidence is double hearsay does not mean it's not cogent. The whole point of Section 1.1 of the Civil Evidence Act is to make that evidence admissible.
And it may or may not be cogent depending on the particular nature of the evidence.
But that's the point. And the fact is that the evidence of Zheglova was understood by the ICC judge to be cogent. It was cogent of predetermination because that is what A, the evidence says, as I showed my lords, and B, because that's what the ICC judge herself concluded in paragraph 131.
Well, she doesn't say it's cogent in 131, does she?
What she says in 131 is the most I have... cogent is a word which appears later. But what she says is she's seen all anecdotal evidence, etc., etc. And then third line, and hearsay evidence of the arbitrage proceedings were predetermined. And then she makes the point that the criticisms of Mr. Drelle don't extend beyond the first Russian court. And because she's labouring, understandably, because of the submissions that have been made to her at the time, to be fair to her, she's labouring under the misapprehension that where one is, that if one's alleged fraud in the first instance judgment, one's still then got to show fraud in the appeal judgments. She goes on to say, but she hasn't seen, seventh line, cogent evidence that points to the existence of any potential interference with the judges in all four courts.
I don't think you can read that as an implied acceptance that there was cogent evidence in relation to the first court.
Well, my lord, I'm sorry, I didn't fully hear your...
Well, yeah. I don't know if the suggestion is that because the judge referred there to there not being cogent evidence in relation to all four courts,
ambiguous.
She was impliedly saying that she accepted that there was cogent evidence in relation to the first court.
But she wasn't, my lord.
She wasn't. So
She wasn't, my lord.
And
Because
indeed,
of
she
117
said in 117 specifically, she doesn't think
Exactly.
it's cogent evidence.
Exactly. So she's making the point that effectively, even if, which is denied, there was cogent evidence
Yes.
in the first court, nevertheless, I haven't seen any cogent evidence in courts 2, 3 or 4, ergo, the attack on impeachability doesn't work anyway.
Can I just go back to 117 for a
Yeah.
second? I obviously, my lord has already asked you questions about the first part of the paragraph,
Yeah.
and about whether this is based upon the misapprehension that because it's hearsay, it's not evidence of the truth.
Yeah.
Just looking at the sentence, it is double hearsay evidence. As such, it is not cogent evidence.
Mm-hmm.
You know, I've got to be careful not to start minutely scrutinising the judge's syntax. If the words "as such" are focused upon, I mean, it could be said, well, it's not every piece of double hearsay that is not cogent, and therefore the words "as such" are unfortunate. If they are there, if it's to suggest that because it's double hearsay, it must necessarily not be cogent evidence. But if you is the judge just not simply saying, this is double hearsay evidence, and my view is I evaluate it as not cogent evidence?
No. Yeah. Is the short... Oh, Mr. You heard Mr. Phillips. He's been very well behaved up till now. Couldn't resist that one. The answer to what your lordship said is no.
Okay.
And the reason why it's a no is for two reasons. One, because that's not what is said. And secondly, because of paragraph 131. Because and I keep hammering this, because in paragraph 131, to be fair to the ICC judge, she has correctly set out the import of Ms. Zeglova's evidence, viz. The case was predetermined. And that's why I asked the rhetorical question, why then does she go on to reject it? She goes on to reject it because of the hearsay / inadmissibility point. And secondly, she goes on to reject it because it doesn't deal with every court.
I have to say, I don't understand why 131 helps you.
Yeah.
I mean, 117 seems a crucial paragraph, and you get the sentence saying it's not evidence. And we'll hear, obviously, Mr. Phillips, but it might be said, well, that's just wrong because it is evidence, whether it's good evidence, bad evidence, or whatever, it's evidence.
Yeah.
Then you get the as such, possibly suggesting, you might argue, that double hearsay is incapable of being such cogent evidence. There's the contrary argument. So there we are. I don't see where 131 takes you any further.
Well, 131 takes me here that it's said by the judge, it's said by my learned friends, that the judge, the ICC judge, discounted Ms. Zeglova's evidence as not being cogent because of all these alleged gaps in the evidence, right? And therefore, there wasn't sufficient evidence of a sufficient weight to raise a triable issue of impeachability. Evidence of sufficient weight would have been where the ICC judge concludes that the evidence of Zeglova was that the arbitrage proceedings had been predetermined. And the reason why I show your lordship 131 is because that's what the judge finds.
But she doesn't. I mean,
in fact, predetermined comes from paragraph 88 of her statement, which is where she's expressing her view, not at that stage the report of the conversation. The expression that she uses, saying, therefore, I have no doubt that the outcome of the claim against Mr. Drelle was predetermined, was her assessment of that conversation.
Absolutely.
And is 131 not saying any more than that?
But fine, my lord. But the fact is, though, if Ms. Zeglova's assessment of the conversation between Labanov and Guschev was that, she was right. And I showed your lordship the passages. She was right. And therefore, what the ICC judge is doing is saying that I have seen evidence that... I don't want to... let's read the words out precisely. What she says is, at 131, the most I have seen, that's how it's prefaced, the most I have seen is ... hearsay evidence that the arbitrage proceedings were predetermined. That's what she says. That's what the judge, she doesn't say the most I've seen is a witness statement from someone who says that. She says the most I've seen is evidence that they were predetermined.
And tying that back to 117, she says, well, that's double hearsay.
Yeah.
And it's not cogent.
I know. That's what's
I'm not sure where 131 adds anything at all.
Well, only... Well, I don't want to... I was kind of going around in circles. I mean, I was not getting through to my lords, but it was to show your lordship that, to be fair to the ICC judge, she had correctly evaluated the evidence on Żeglova. That's to say, what did it mean? What it meant was that there was evidence that the case was predetermined. The next question is, well, fine, she having found that, why then does she discount it? And the answer is, because she's still labouring under a misapprehension as to admissibility. Or secondly, because it's double hearsay.
The curiosity I've got, I've shared my lord's slight puzzlement about this. I mean, 117 you subject to criticism, and I can see why you do it, because it starts with, the test for admissibility, you say, which is wrong, and then it seems to suggest that because it's double hearsay, it must, as such, not be cogent without any actual evaluation. But then, when you do get to 133, you stress that the judge is recognising that she does have in front of her hearsay evidence that the result was predetermined.
Yeah.
So, I mean, I'm not sure whether you're congratulating her on 131 or criticising her for 117. And I'm just not sure where you're
I'll
at.
tell you exactly where I'm coming from. What I'm dealing with, first of all, is the suggestion on behalf of by the judge that the ICC judge discounted the evidence of Żeglova as not being cogent or sufficiently cogent of predetermination because of all these gaps. And what I say in response to that is that's not right. First of all, as the judge accepted, ICC Judge Burton doesn't say that. Secondly, she doesn't identify any gaps. But thirdly, in 131, she actually says what the import of the evidence is. And then, I mean, it is a real puzzle. So I'm not sure I go so far as to employ the verb congratulate, but she certainly did get to the right result as to the import of Żeglova's evidence. Then one is
she gets to the right result in 131 as to the import of Żeglova's evidence.
Yes.
Why are we spending so much of our time thrashing around over 117?
Because I've got to explain to your lordships why she went wrong and show why she went wrong, and that is she then discounted her own conclusion, either for two wrong reasons, either because the evidence was, she thought, inadmissible, because she was labouring under a misapprehension induced by my learned friend's original submission, or because it was double hearsay. Both of those reasons are wrong.
I thought she discounted it because of the forecourt point.
I'm sorry, the what point?
The forecourt point, i.e.
That as well. That's another reason why she discounted it. Third reason, which is also wrong, because what she does in my lord, in 117 is to give two reasons for apparently discounting the evidence. The first is the as such, which follows on from the double hearsay / inadmissibility point. And then she makes this further wrong point, which is that, well, in any event, it doesn't deal with alleged fraud on the part of the other Russian courts, which is wrong as a matter of law, as we'll come to the appeal points, because Mr. Justice Richards, with respect, got that wrong as well. So that's the point of it, lords.
And we better move you on,
yes,
otherwise you're not going to get to the end.
Yes. So, my lords, so I'm not going to repeat, in view of time, the submissions we make in writing at paragraph 45B to G of our skeleton. That's where we address point by point, each of the alleged criticisms / gaps identified by the judge, and we deal with those, and oral submissions won't improve on what we've said in writing, if I can put it like that. So, as I said, the ICC judge never said there were any gaps. And as your lordships will have seen from paragraph 90 of the judgment below, A101 in the core bundle, the judge acknowledged that his analysis doesn't appear on the face of the judgment. And this is where I just, without going back into the debate, and one's left wondering, at least we are left wondering on this side of the court, as to whether, has the judge, Mr. Justice Richards, gone down this route by reinterpreting, reinventing these reasons, absent a respondent's notice, in any event, but whatever, because he considers he should show a high degree of deference to the judge's conclusion. Is he, I ask this rhetorically, bending over backwards to try to salvage the reasoning for the ICC judge's conclusion, which, and if he is, it's wrong, because what it's resulted in is his ignoring the actual reasons she did give. And this high degree of deference is mentioned again at paragraph 121 of Mr. Justice Richard's judgment at A107. Now, I don't know the answer to that question, because obviously I'm not inside Mr. Justice Richard's mind with respect. But it is a real puzzle that, faced with, frankly, what seems to be pretty clear on its face in 117 and Parche, your lordships, 131 as to the import of Jeglover's evidence, that Mr. Justice Richards didn't take this at face value, and I use that expression not in any superficial way, but just on the basis of, well, this is what the judge, ICC Judge Burton, found. He simply didn't deal with it on that basis. My lords, the ICC judge may well, at paragraph 60 of her judgment, that's at A50, she may have reminded herself of Long and Farrer, but she didn't follow it as regards Ms. Jeglover. Once Jeglover's evidence was before the judge, and I've also got my submissions on what it actually meant, given the interpretation which it bears, and indeed her interpretation, I submit, then what she then needed to do was to ask herself whether Ms. Jeglover's evidence could be rejected without cross-examination because it was manifestly incredible. She didn't answer that question, and she wasn't entitled to dismiss it or discount it because it was double hearsay or inadmissible or for the reason in relation to the Russian appellate courts. The real issue was whether the evidence of the Lobanova-Guschev conversation and what was stated in it was manifestly incredible, and the ICC judge made no finding to that effect. My lords, I'm going to not take your lordships to it, because obviously my Lord Justice Newey and Lord Justice Snowden well remember the case. But Kirieva, your lordship, although my Lord Justice Snowden will be happy that the Supreme Court, of course, agreed with my lord in relation to the immovables rule.
Actually quite happy that Lady Justice Falk managed to reach the same result that I'd reached by a shortcut, but yeah.
I mean, to be fair, this is slightly different, isn't it? Because it's not a question of disbelieving Miss Jeglover necessarily. You can perfectly well believe everything that she says that she was told, and still say, well, it's, this evidence just doesn't amount to anything.
That would be very odd, given the one can posit a case where a judge might believe what is said by a witness and then say, well, it doesn't amount to hill of beans. One can imagine that. But that isn't this case. I've taken your lordship through the paragraph. That isn't, and then again, without repeating, I think I'm repeating it now to death, but we've got the ICC judge's own assessment of it. But I take your lordship's point. Your lordship is right in the way your lordship puts it. But the reason why Curieva is relevant, because what Curieva in this court is authority for the proposition of, is authority for, is that is as I said, that having got the evidence, the judge then needed to ask herself, well, is it manifestly incredible? That was the question, and that was what your lordship held.
But to take my lord's point, I mean, if suppose the judge was to say, well, I think Mr. Glover's evidence is perfectly credible, I can believe that.
Yeah.
But it doesn't answer the question about whether that's sufficient for the purposes of injustice if there are appellate courts that you're not criticising. Yeah,
but that's the point, which is that's the legal misapprehension, because the law is, as Mr. Justice Richards accepted, and unfortunately it wasn't so submitted to ICC Judge Burton, unfortunately, by counsel then appearing. But the law is, as Mr. Justice Richards sets out in his judgment in paragraph 124 at A108, and that is, if one can impeach a fraud, I bias as here, the lower court judgment, then it doesn't matter whether the litigant has availed himself of routes of appeal, and it doesn't matter what the view of the appeal courts are. It just doesn't.
Speaking for myself, I'm not sure that is what the authorities decide. I quite see it's irrelevant if the question of fraud has been investigated by a higher court on appeal, and the views of the higher court may not be relevant. But if you have what is a rehearing, and what you're saying is procedurally what happened first time round was contrary to policy, unfair, however you want to express it. But there is no reason, let it be supposed, for thinking that the complete rehearing is tainted by any unfairness. Why should that be irrelevant? It seems very odd to me. Well, so I speak for myself. I would like to be shown some authority that says that.
Which is it? Paragraph 124(1) you're looking at?
And
but that's not what it says.
Well, the submissions were wide. The submissions were wider below. A litigant who can show that a foreign judgment obtained by fraud can impeach the judge of the English courts if they haven't used every
even if they haven't used the available remedy. But suppose they have used the available remedy in the foreign court, namely to appeal, and the appeal court says, well, we've heard all your arguments about, you know, the chief judge of the
chairman,
the chairman. You know, we've looked at it again for ourselves, and actually, whatever he thinks, we'd have come to exactly the same view, and you're not suggesting that they've acted wrongly. That's not what this is about.
Well, the answer to that point is, first of all, there wasn't a full rehearing, it was a full review. It wasn't a full rehearing, it was a full review. That's the word that's used. But secondly, the answer is also what's set out in Roman 2 of paragraph 124. A litigant who asserts a foreign judge should be impeached for fraud in the English courts, making an argument based on English law, the English courts determine the views of the foreign court on whether there has or hasn't been fraud are not relevant. And the foreign court includes any appellate court, because that's what the appellate court of the foreign court is the foreign court.
Is that what Lord Justice Taunton said?
He didn't. I don't think he said in. I don't think he expressly. I had to get the case.
Like Lord Justice Popplewell, I have some problem with the suggestion that it's basically irrelevant what was said on appeal, because there's evidence, assuming it to be credible, as to what might have been in the minds of the first instance court, or what they were about. I just...
Lords, if one goes, so Lord, if you want to take up the authorities bundle, please, and go to page 815, paragraph 42, tab 42, 815.
Sorry, which paragraph?
815, and it's Dicey Rule 53.
That's it.
First of all, in relation to review, if your lordships, just before we look at this, look at the core bundle, please, A4/A48, please. A4/A48. That is part of the
This is the Court of Appeal judgment.
ICC Judge. Sorry, this is in the core bundle, A48.
We're in one of the judgments.
Just tell me what.
I'm sorry, because it has it loose. I'm so sorry.
I've got various things in this.
ICC Judge Burton.
Thank you.
Sorry.
And which paragraph?
53. Under the Court of Appeal, Mr. Drelle appealed the decision of Judge Frolovichova, the Court of Appeal. Professor Stefan's expert evidence explains the Court of Appeal conducts a full review.
Providing the appellant
Yes.
with a further opportunity to succeed on the merits.
Yes.
I mean, I understood that was effectively a rehearing. No?
Well,
Well, we've seen. We've got the Court of Appeal judgment itself, and we can see what they
yes.
did.
Yes.
It seemed to be a complete reconsideration of the merits of the argument.
But it doesn't matter because the judgment that is being proceeded on for the purpose of this petition is not the appeal judgment. It is the judgment of Judge Frolovichova at first instance. That's the judgment. And we say it's that judgment which is impeachable for fraud. And it doesn't matter.
Well, that would lead to very odd results. Take a domestic case
Yeah.
in which Mr. Justice Popplewell is sitting at first instance,
Right.
and he's accused of bias,
Yeah.
and an application that he should recuse himself fails, and it goes on appeal, and the Court of Appeal say he should have recused himself. He was biased. Now we, the Court of Appeal, are going to consider the case from the start again, and as it happens, we think that he got the right result, and therefore the appeal would be dismissed, and his judgment remains.
Yeah.
You could you then impeach that?
Well, no, because that's an English judgment, a different.
Well, but
different
you see
rule.
what I mean. That would be most surprising if that happened in a foreign context, wouldn't it? To say you can impeach that just because procedurally it was the decision of the appeal court that the judgment should stand.
Well, if your lordships look at, please, the Dicey extract, which is at 815 in the authorities bundle, about impeachability for fraud.
Yes.
14136, reference to Appellant and Oppenheimer. And then page 818, reference to Jet Holdings, which was Lord Justice Staunton.
Sorry, 818.
Page 818, bottom right.
Yep.
14138, Jet Holdings, bottom of the page. Court of Appeal also reaffirmed it is irrelevant that in the view of the foreign court there was no fraud. And then reference to House of Spring Gardens.
But does that must mean presumably no fraud by the party?
No, well, fraud, well...
Does that mean does that mean that if the foreign court says I'm not being fraudulent, I mean it's a bit without going to the facts, it's a bit difficult to understand exactly what's meant there.
No, that I think was fraud by the parties. My recollection of Jet Holdings and Patel was that there was threats of violence by a party. So it wasn't, but the Dicey Rule 53 encompasses fraud by the court. It's not limited to fraud by the parties.
I know.
And then...
but your case here is, well, bias anyway on the part of the court, you say.
I need to find, there's reference. Yes, then if your lordships goes to page 832, That's in the context of natural. Yes, well, actually, my Julia reminds me, we set this out in detail in our skeleton below, which is a supplemental bundle D30, thank you. So the bottom of D29, first of all, what we submitted, immateriality of the appeal process before the Russian courts. 60, judge held relying on Adams and Cape Industries, where a procedural defect is apparent to defend, he should use the local remedy of appeal before contending the assessment of liability was in accordance with principle of natural justice. That may represent the law in relation to a case where, as in Adams, there was no fraud. It's not the law where what's alleged is fraud within the meaning of Dicey Rule 53, such as now it's nothing to the point that the matter wasn't raised on appeal. Long line of appellate authorities. Adams, Lord Justice Slade noted, it is at least clear that our law doesn't oblige a defendant who can show that a foreign judgment has been obtained by fraud to have used any available remedy in the foreign court.
With respect, that's not the point. The point is, suppose he does use the available remedy of appeal in the foreign courts.
That goes on then, my lord.
Right.
So then 63, any available remedy in the foreign court plainly includes appeals. 64, principle in Abeloff, which we set out. And then 65, as Lord Justice Snowden held in Jet Holdings, decision in Abeloff and Oppenheimer show a foreign judgment can't be enforced if it was obtained by fraud, even though the allegation of fraud was investigated and rejected by the foreign court. I would conclude that the foreign court's views on fraud are neither conclusive nor relevant, whether fraud is said to be fraud going directly to the cause of action, and so on. Then 66, we submit the foreign court's views on fraud plainly include the views of a foreign appellate court as being part of the same foreign court. And then we say it's nothing to the point the fraudulent nature of the judgment of first instance investigated and rejected, including on appeal, so on. And then in any event, the judgment upon which the respondent founds the petition in this case is not an appellate judgment, but the Russian judgment itself.
So you have no authority for the proposition in 66, as nothing beyond what we see there. So to take my Lord's example, you'd say the Court of Appeal's view on the merits is irrelevant if you can show the first instance judge was biased.
Of a foreign judgment, I'm not talking about a judgment in this jurisdiction, where different rules apply. Of a foreign judgment, that is the submission I would make.
And can you explain to me why that should be the position? What as a matter of policy or good sense should lead to that result? If the reason that you've ended up with a foreign judgment is that it has been looked at by three people, let us say in the Court of Appeal, who have come to an independent decision in circumstances which are unimpeachable. Why in those circumstances should the mere fact that as a matter of procedure what they've done is confirm the order of the first court mean that you should be able to set the whole thing aside because you would have been able to impeach the first instance decision had it stood alone? What's the commercial sense in that?
Well, it's not a question of commercial sense.
Policy.
It's the policy is this, that if the position is that there is no obligation on the litigant to appeal, and if the views of the foreign court are irrelevant, then that leads, we submit, to the submission that I've made, the proposition in question. Because when one's dealing with foreign judgments, if the judgment relied on whatever may have happened subsequently, if that is infected with fraud, and as far as the English court is concerned, based on what we say is the correct analysis of Adams and Jet Holdings, that's the result which should follow. I accept that.
Sorry, go on. I was only going to say, and I can't remember the substance of this case, even though I sat on it. I sat on a case in, I think it's the COSA litigation, which has produced lots of decisions. sitting with the Chancellor, Sir Julian Flo, and I think Lady Justice Simler, where there was a similar sort of point, but I can't remember exactly how it worked, but it might be worth checking that.
I'll look at that.
That might be more or less the last case in the COSA litigation, I think. Assuming I've got the name right.
If the proposition is that the litigant is not obliged to appeal, then they shouldn't be in a worse position if they did appeal and the appeal court came to some other view.
I mean, obviously the difficulty is if it was a true rehearing, so that the court was just starting from scratch, then you might think it's irrelevant what happened before.
Well, if it was a true rehearing where the appeal court then makes its own judgment, and then what is sought to be enforced is that judgment, then I accept the position, because what's gone on before is water under the bridge. But this was a review. I appreciate the language used by the judge, but it was still a review. The words rehearing is not used. Your Lordships may come to a different view. Your Lordships may come to the view that really means the same thing. Well, that's a matter of your Lords. Your Lordships have the submission. But the point is the judgment that is sought to be enforced, irrespective of what happened subsequently, is the original judgment. And that judgment was, we say, infected by fraud, or at least for present purposes, a triable issue. So if one is at the position that the foreign judgment to be enforced is impeachable, then this court, the English court, should not enforce it, will not enforce it. I can't put the submission any higher than that. That is the submission.
Thank you.
Then, my lords, dealing with the point about whether the case was heard or largely heard, that was wrong on the facts. So, your Lordships will recall the date of the discussion between Lobanova and Guschev was the 26th of January. Your Lordships take the supplemental bundle up, please, and go to B46. One can see footnote 160, which corresponds to the first sentence of 223 on that page, that there was a further ruling of the Commercial Court 2 days later, on the 28th of January, 29.
You're B46.
B46 in the supplemental bundle, paragraph 223, there's footnote 160 in the third line.
Sorry, right, okay. Yep.
And that refers to a ruling of the Commercial Court, which is the relevant court, of the 28th of January, 2019. That's 2 days after. Did your Lordship see that?
Yeah, I do.
Yeah, that's 2 days after the Lobanova-Guschev discussion. And then there was another hearing and ruling on the 19th of March, and your Lordships see that from, if your Lordships go, for example, well, on the same page, B46, at 164, footnotes 164, 165 and 166, the hearing on the 19th of March 2019. And then your Lordships also see on the same page that there was a written submission made by GPN, footnote 163, on the 19th of April 2019. And then the resolution part of the judgment, which is the dispositive part of the judgment, came out on the 24th of April 19 with the reasons which followed a month later.
So it came out on what date?
So the dispositive. So if your Lordships go to C4 in the supplemental bundle, which is the first page of the Commercial Court, your Lordships will see the date of the decision, about 3 lines down left-hand side, is 24th of May 2019. But it says operative part of the ruling was announced on 24 April.
Yes.
So the fact is the case was ongoing. And moreover, Mr. Kulkov didn't accept the claim had been largely heard, whatever that means, as the ICC judge found at 116. Because if your lordships look at, in the supplemental bundle, please, B47, paragraph 231, what Mr. Kuklov is doing is commenting on what Mr. Brown, who was the solicitor for the petitioner, was contending. Mr. Brown, it was, who said that to the extent that any of the conversations did take place or the contents of those conversations are true, the court proceeding had largely been heard by this date. It wasn't Kulkov accepting that, and he then goes on to say, natural justice and the fair trial principle imply that the outcome of any dispute can't and should be known in advance. There can't be any largely heard approach. So, in any event, the evidence of Ms. Zheglova was not that Ms. Lobanova had seen Mr. Gustchev after the trial and he had said, oh, look, by the way, the case is over, the judge has written her judgment, but psst, I'm going to tell you the result in advance. That wasn't her evidence at all. It was we cannot win, would not be able to win the case. And then, my lords, in the judgment of Mr. Justice Richards at 91, paragraph 91, which your lordships find also at page A101 of the core bundle. His lordship said, even if Mr. Gustchev was the source of the can't win statement, that wouldn't lead inexorably to the conclusion the case had been predetermined. By the time of the Lobanova-Gustchev conversation, the case against Mr. Drelle had been proceeding for some time. To be cogent, at least, it needed to set out some basis for a conclusion that the case had been predetermined. Well, that with respect is surprising and wrong. First of all, for the president of the regional commercial court, who wasn't trying the case but nevertheless has a decisive say in the result, to say that Mr. Drelle can't win when the case is still live and judgment not delivered, as it raises a tribal issue, at least that the judgment is impeachable. And for the judge to say in 91 that to be cogent, it needed to set out some basis for a conclusion the case had been predetermined, is to set Mr. Drelle a bar which is higher than a real prospect of success and even higher than a balance of probabilities. And secondly, the case may well have been proceeding for some time, but it wasn't done. That was the key point. And there was, in any event, a compelling basis for a tribal issue, and I've already addressed your lordships on that, and I've already shown you lordships paragraph 73 of Zheglova and paragraph 82 of the judge's judgment about the role of the regional chairman. And then, my lords, the judge in the last sentence of 91 said the judge was entitled to conclude that even if Mr. Gustchev was indiscreetly and inappropriately commenting on the outcome in advance, that wasn't on its own evidence of predetermination. Well, first, Mr. Gustchev wasn't commenting on the outcome. He was saying what the outcome would be, because GPN was driving the case, and that raises at the least a tribal issue. And secondly, in the light of what the judge had accepted at 82 about the role of the regional chairman, to describe Mr. Gustchev as, quotes, indiscreetly and inappropriately commenting on the outcome of the case in advance, or the outcome in advance, is a bit wide of the mark, shall we say.
You also say, well, Judge Burton didn't say this.
No. And to be fair, we've had to face here a bit of a moving feast. You know, one came before Mr. Justice Richards thinking one was fighting an appeal on the basis of what ICC Judge Burton had said in her judgment. Instead, it appears that we were fighting an appeal on a different basis, and that's not fair, with respect. And then, my lords, already addressed your lordships on the appeals. Very briefly, Maximov, case of Maximov and Star syndicates. that's at Authorities Bundle 30, tab 30 at 546. Say briefly a word about that because my friends rely on it and star. That was a case where the claimant sought to enforce an ICC award made by some rather distinguished Russian arbitrators. The defendant applied to the Moscow Arbitrage Court to set it aside on the grounds that two of the arbitrators hadn't disclosed links to an expert witness called by the claimant. The Russian judge upheld the non-disclosure ground and said the award was contrary to public policy and that the claimant's dispute wasn't arbitrable, could only be heard by the Russian court, so the award of the ICC was set aside. There were further appeals which failed. And then the claimant applied here to enforce the ICC award, and they argue that the Russian court judgment shouldn't be recognised because it was so extreme and incorrect as to show that the Russian courts weren't acting in good faith. And at page 555, Sir Michael Burton set out the law, having left aside an argument of ex nihilo nihil fit, which had been raised.
So, sorry, which page?
555, my lord.
Thank you.
And then at
Hang on,
5...
Could you just translate that for me?
Oh, so what it means is it's from nothing becomes nothing. And the point that was being made was because the award had been set aside, therefore there was nothing further to argue about. So that was the submission.
It's either Latin or the sound of music. Nothing comes from nothing. Nothing ever could. And the sound of music.
It's also that, isn't it? Then one thinks of Shakespeare, which if
That's
nothing,
a rather more profound reference.
yes, and of course he's deceived because of course there was something going on. It wasn't nothing. You know, if nothings have these nothings, then this be nothing. Anyway, and then my lords, at page 574, paragraph 53. His lordship said that the claimant bore a heavy burden to establish that the decisions of the foreign court weren't only wrong or manifestly wrong, but they were so perverse as to, that it was to be concluded they could only have been arrived at in bad faith or through bias. Now, of course, that phrase, a heavy burden, may be questionable because, of course, there was a burden, but the burden is on a balance of probabilities. And obviously, the more serious the charge, the more cogent, to use that adjective, the evidence has got to be. But it's not necessarily a heavy burden, it's the same burden on a balance of probabilities, be that as it may. But there are a number of points to make about this case. First of all, it wasn't a summary judgment case, it was a trial. Secondly, there's the heavy burden point I just made, which with respect to Sir Michael, is inaccurate. Thirdly, if the judge was intending to state that fraud or bias needed to be shown in every Russian court, then he was, with respect, wrong, and I've discussed that with my lords already. And fourthly, this, as I said, was a trial, and the judge, in any event, didn't make any findings of bias in relation to the first decision, and therefore it didn't arise.
So is this help me with the fact, is this a case where what is being said is it can be inferred? There's no direct evidence of either bias or lack of good faith.
Exactly.
And you have to infer it from just the sheer bizarreness of the decision.
Exactly so. And that's an important also further distinguishing feature, because in our case here, Mr. Drelle doesn't just rely on the expert evidence as has been relied on in many cases involving Russian or Ukrainian or Georgian courts, but he actually had direct evidence from a witness, Miss Zheglova. That's a further distinguishing feature. And then, as far as Star Syndicates is concerned, my lords, that's Appeal Bundle tab 32, page 610. That was a claim for recognition and enforcement of 3 Russian court judgments before Mrs. Justice Mulder, and the claimant made, as claimants tend to do in these cases, a summary judgment application. And at page 617, Her Ladyship addressed the relevant legal principles for summary judgment, paragraph 39, all uncontroversial, all with respect correct. And then, importantly, actually, she did refer paragraph 43, page 620, to the well-known dictum of Lady Justice Arden in Berezovsky, where there was a conflict as to the evidence of Russian law, which was said to be relevant in that case. Therefore, there was a dispute as to fact, foreign law, of course, being a question of fact, and it wasn't right for the court to make summary findings where the experts were clashing. And then, my lords, one sees at 620, paragraph 44, that there were two grounds to challenge the summary judgment. One was lack of jurisdiction, the second was bias, and Mrs. Justice Mulder at 636, paragraph 94, held that there was a real prospect of success for the defendants to establish that as a matter of English law, question of whether the Russian court had jurisdiction was a matter of construction of Russian law, which could only be determined at the trial. She referred to the relevant rule in Dicey in relation to fraud, and at 98 referred to the Maximov case and held at 138 Roman 1 at page 644 what the defendants would need to show at a trial, and they had established that the bias defence had a real prospect of success. So, although it matters not in the result, because Mr. Justice Mulder, with respect, came to the right decision, that's to say she resisted the siren call and said that it had to go to trial, but to the extent that she followed Maximov, which was authority in which Sir Michael had said that fraud had to be shown, which is a different point from the point my Lord Justice Popplewell put to me, but that fraud had to be shown in any event in each of the Russian courts, to the extent that that was a reference to showing fraud in courts where there was recognition wasn't sought on any judgment in such court, then that was with respect wrong. My lords, that's ground 3. Can I turn to the last ground, please, which is ground 4. And, my lords, the appellant's case on appeal before the judge was that Mr. Loft's evidence and Mr. Kulkov's evidence, taken together with the critical evidence of Ms. Zheglova, showed or disclosed that there was a triable issue as to impeachability. And that was clearly there in our skeleton. I'll just give your lordships the references. Paragraph 80 in supplemental bundle, page D40.
Sorry, can I have the reference again?
Yes, sorry. Paragraph 80.
Yep.
That's supplemental, all supplemental references, obviously. D40.
Yep.
91E at D44. 94 at D45. And 98 at D47. So the judge should have stood back and asked himself whether, looked at as a whole, it was fanciful that the Russian judgment was impeachable for fraud, that it had been predetermined. Now, although the judge appeared at paragraph 102 of his judgment, which your lordships also find at page 104, A104 of the core bundle, although he appears to have broadly correctly summarised the submissions, nevertheless, and also, to be fair, at paragraph 114, which is at page 106, he then fell back on asking, in relation to Mr. Kuklov, at paragraph 103, whether his evidence was of itself enough to establish a triable issue. And then 104, the last a few lines is, while Mr. Kulkov's expert report suggested there may have been errors in the judgment, those alleged errors didn't raise a sufficiently triable issue, suggesting he's just looking at that. And then 106, when his lordship said that there wasn't identified those aspects of the expert evidence that are said to point in favour of the proposition that there was a triable issue, that the judgment was deliberately wrong. And then 107, at page A105, first line, Mr. Drelle has struggled to show a triable issue to the effect that the judgment was deliberately wrong solely by reference to alleged errors in the judgment. And of course, that wasn't the case we were advancing. And then in relation to Mr. Loff, my lords, paragraph 115, at page A106, last sentence, his lordship says the judge was entitled to conclude that his evidence was insufficient on its own to establish a triable issue, since it said nothing about how the particular proceedings against Mr. Drelle had been conducted. So, my lords, again, before I come to what Mr. Loff and Mr. Kulkov stated by way of their professional opinions, again, I respectfully remind your lordships, you don't have to turn it up, I showed your lordships the reference to it in Mrs. Justice Mulder's judgment, what Mrs. Justice Arden said in Berezovsky about clashes on expert evidence. What's happened here, my lords, is that the ICC judge and Mr. Justice Richards failed correctly, we say, to understand the substance and import of the expert evidence. The ICC judge approached it piecemeal and selectively, and held that even if accepted, it wasn't probative of the Russian judgment being impeachable. It didn't even raise a triable issue, and she then fell into further error because she held the expert evidence didn't disclose a triable issue of impeachability in all of the Russian courts, which I've already addressed you. She does, it's true, later on say, I have to stand back and look at it as a whole, but the way she engaged in that exercise was misconceived. And let me turn, my lords, to Mr. Loff. Then I'll take Mr. Kulkov. The starting point is what the judge himself said at paragraph 115 in his judgment at A106. 5 lines up from the bottom of that paragraph. His lordship said of Mr. Loff's evidence, it was certainly capable of supporting Mr. Drelle's case, since it suggested that judges in Russia might exercise partiality in favour of GPN. But the last sentence of 115 indicates, or illustrates rather par excellence, we submit, the error of the judge, because as I showed my lord, he says that Mr. Loff's evidence was insufficient on its own, because it said nothing about how the particular proceedings against Mr. Drelle had been conducted. Now, that wasn't the purpose of Mr. Loff's evidence. His focus wasn't on the particular proceedings. The purpose of his evidence was to provide context for Mr. Drelle's proceedings and what happened in them, namely what Ms. Sheglova's evidence revealed. And he wasn't asked to opine, as I say, on those particular proceedings, how they were conducted. That was Mr. Kulkov's remit. And it was Ms. Sheglova's evidence of what had occurred and that of the other expert, Mr. Kulkov, who gave evidence of serious errors in the Russian court. And that was all suggestive of a judge Frolovcheva, who was determined to find against Mr. Drelle because GPN was driving the case, irrespective of the merits and irrespective of Russian law. Then, my lords, at paragraph 112 of the judgment, at page A105, the judge referred to paragraphs 125 and 131 of the ICC judgment. That's which your lordships find at pages 69 to 70. And in your lordship sees from paragraph 125, A69, that the ICC judge began by said that Mr. Loft's report made for uncomfortable reading. With respect, that was an understatement. She then went on to hold that Mr. Drelle's case didn't fit into the specific examples he gave of improper interference. And she...
so where are you? I've
so
lost
at 125
of
ICC judgment, page A69.
Sorry, swap one. Yeah, right. Yep.
Yeah. And she said that it didn't fit into the specific examples he gave of critics of the state interference in the nationalisation of energy resources, criminal proceedings. Those are three examples she picked out. Then at 131, my lords, page A70, the ICC Judge Burton referred to what she called anecdotal second-line evidence that the Russian courts would be reluctant and or highly unlikely to rule against GPN. That's a reference to Mr. Loft. And those statements wrongly downplayed to a serious degree, beyond what was within the spectrum of a reasonable interpretation of what Mr. Loft said. And if your lordships can just take up his report, which is a supplemental bundle, please, at B4, where your lordships see his bio, which is pretty impressive. Paragraph 1, Associate Fellow.
Sorry, where are you?
B4, my lord.
Yes.
Paragraph 1, last sentence.
Yes.
Associate Fellow at Chatham House. Then he was, third line, paragraph 2, at Sandhurst, and a NATO official responsible for public information activities in Russia. Fluent Russian speaker. And then, my lords, at B7, 8, 9 and 10, he basically sets out, I don't have time to read it now, he sets out his opinion as to the Russian judicial system and its lack of independence. And basically what he says is, Russian judges know that when it comes to Russian state actors, that they know what side their bread is buttered on. And it's a foolhardy judge who's going to find against a Russian state actor. And my lords, and he says at B10, paragraph 17, 11 lines up, 12 lines up, that Prime Minister Medvedev, in his more moderate days, called Russia a country of legal nihilism. It's important, says Mr. Loft, therefore, for Western observers to avoid presumption of regularity. And then he goes on at B11, paragraph 50. The cases above, which he had set out various cases, all demonstrate a disturbing lack of judicial independence in Russia and how the ruling group has no difficulty in using the courts to steal assets and silence his enemies. As I'll discuss below, Gazprom Neft, that's GPN, as an entity majority owned by Gazprom, benefits from this system, as do other state companies controlled by representatives of the ruling group. Important to recognise in these cases that a small group has effectively privatised state assets and operates them for its own benefit. And then 51, with an important paragraph, Mr. Loft says, page B12, this doesn't mean a state energy company will always win in court. It depends on who it's facing. For example, there are plenty of examples of subsidiaries of Rosneft and Gazprom Neft losing tax cases in the regions of Russia. However, I recently asked a former senior executive in a major Gazprom subsidiary whether GPN would assume that it would win in a Russian court against an individual. The person replied without hesitation, yes, 100%. From desktop research, I'm not aware of cases where an individual has won their case against Gazprom Neft or its mother company, Gazprom. Then he says, last sentence, this doesn't mean there will not be isolated instances when an individual does win a case, but these appear to be extremely rare when the issue at stake doesn't escalate to the highest level of the state company. And, my lords, in that regard, the important feature of this case is it did escalate to the highest level of the state company. Your Lordship see that from a document in the supplemental bundle, please, at A28, and that is a letter written, dated the 23rd of June 2016, from GPN to the head of the main Directorate for Economic Security and Anti-Corruption Enforcement. Sorry, Lord, A28.
Oh, yes, I see. Yeah.
Letter, 23rd of June 2016, from Mr. Dukov, who's the General Director, we see that at A31 of GPN, to Major General of Police, and it's sufficient just to show, my lords, these references. Dear Andrei Anatolievich, he begins, we hereby like to inform you about the circumstances in which a damage of about 10 billion rubles was caused to GPN and thereby the Russian Federation, as Gazprom, their PJSC's controlling shareholder, because the participation interest held by Gazprom in GPN is over 95%. Then there's an allegation that of an organised criminal group, and if your lordships can read this if one wants, but if your lordships then go to A30, please, just above the second punched hole, special attention should be paid to serious public danger of the acts committed, because the damage over 10 billion rubles was de facto caused to the Russian Federation. So this shows that GPN regards itself as the Russian Federation, effectively, and rightly so, given its shareholdings, and therefore it bears out the point, Mr. Loff, this is a case which has escalated to the highest level of the state company. And then, my lords, for what it's worth, going back to Mr. Loff, please, at A in the supplemental bundle.
So why is it? Sorry, why is it so bizarre that it should, if the company itself loses 10 billion, that or whatever it is, that you might make the point to a shareholder that their shares have suffered a loss?
No, the point is not bizarre. The point is that this is a case where it's been escalated to the highest level of the state company, and that is shown by the general director getting involved and, moreover, making representations. This is serious because it also involves a loss to the Russian Federation. That's all the point is. Mr. Locke was referring to it being extremely rare for an individual to win against a state company such as GPN, and particularly where it's been escalated to the highest levels. And I'm simply showing this to your lordship to show that it's plainly been escalated to the highest levels. That's all.
Okay.
Lords, then at B, please, page 20, B20, Mr. Locke referred to Ms. Jaglova's testimony and said in the last sentence, he said, Chair of the Court, the influential figure, in my view, conclusion allegedly drawn by Ms. Labanova after a telephone inquiry is entirely logical. With GPN driving the case, Mr. Drelle stood no chance of winning in court, which appears to be effectively a repetition of what was said in 83 of Jaglova. And then he says, over the page in 72, current system of governance in Russia makes it impossible for individuals and entities not associated with the interests of the ruling group to assert their rights in dispute with the Russian state or those who control it. In these cases, courts are not independent and there is no rule of law. GPN is a powerful player in view of its close association with the seat of power, the fact that no investigator, prosecutor or judge can ignore without risking disciplinary action and consequences for their career. Against this background, Mr. Drelle's difficulties are no surprise. I mean, that's pretty starkly evidence. And the ICC judge didn't, within her reasoning, expressly refer to that. She just referred to the three categories of specific example which Mr. Loft had given and wanted to see whether Mr. Drelle's case could neatly slot into one of those three. But this entirely missed the point. And indeed, the judge at paragraph 112 fell into the same error, because what the ICC judge did and what the judge with respect has done is to, instead of focusing on the opinion of the expert, has focused on some specific examples the expert has given, which partly explains the opinion. The question is not whether the current case fits in to some of those specific examples. The question is whether the current case bears relation to the opinion that's expressed. And as far as the opinion is concerned, the ICC judge could not dismiss that and not effectively count it as naught or relegate it to saying no more than three specific examples, which was wrong anyway, not least because it was effectively a summary judgment application.
Does Mr. Loft say anything about the appeal system?
Only, let me look. Well, there's one overarching point he makes, which is about Russian judges generally. And so, if, I think I just showed my lords in the relevant passage, because the comments he makes about Russian judges are going to apply on the face of it to any Russian judge at whatever level.
So every judgment in favour of a Russian state entity against any individual is ipso facto permeated by bias and fraud.
Suspect is suspect. Unfortunately, I mean, it may be startling for us in this jurisdiction to comprehend, but effectively that is what he's saying. If you've got a state actor involved, like GPN, and you're not, and GPN isn't against some other party, for example, which has connections to some other ruling clique or some other clique in Russia which has more power, then what's going to happen, unless it's some anodyne case, which this isn't, what's going to happen is the state actor's going to win. That's what his evidence amounts to, shocking though it is. That's what his evidence amounts to. And yes, and in fact, which page is this? At page B8, Mr. Loft refers to the International Commission of Jurists report on the state of the Russian judiciary, that's in 2010. Threats to judicial independence are reportedly particularly acute in cases where powerful political or economic factors have an interest in an outcome of a case, but pressure on judges permeates the judicial system as a whole. Such pressure can, although they by no means always do, affect a court's ability to deliver justice in a wide range of cases. The way judiciary operates puts pressure on judges through a complex system which isn't always apparent or visible. The problem isn't one of external pressure only, but to a great extent has to do with internal mechanisms and bureaucracy. These internal mechanisms have become more significant as a result of the government's drive to strengthen powers of the executive, known in Russia as strengthening the vertical of power. Methods of inappropriate influence on judges are multifarious and range from manipulation of promotions or benefits to applying pressure on a judge regarding a concrete case, and the chilling effect on judges of dismissing colleagues perceived to be too independent or outspoken.
No, I think we need to finish by half.
We do. So, so that was Mr. Loft's report. And that was powerful evidence, we say, and extremely cogent evidence, which raised serious concerns about the Russian judgment, and even picking up what my Lord Justice Snowden mentioned, appeal courts, because even if your lordships think that it was material, that it went through for a full review to the appeal court and then it was subsequently looked at, although at a higher level because they were cassation courts. The fact is, what Mr. Loft has said raised serious issues which could not be disposed of, I submit, adversely to my client in a summary disposal hearing. And when looked at all the other evidence in the round. As far as Mr. Kulkov is concerned, to turn to that, my lords, I refer your lordships to what was said in paragraphs 102 and 103 of the judgment. We, in our skeleton at paragraphs 79 to 80, before the judge below, which is a reference supplemental D40, we make the point about that Kulkov's evidence had to be looked at cumulatively. The judge at paragraph 106 says, Mr. Drelle's submissions in support of ground 5A haven't identified those aspects of the expert evidence that are said to point in favour of the proposition that was a triable issue judgment was deliberately wrong. With respect, that's a puzzling holding, since we made submissions that Mr. Kulkov had identified a swathe of major errors, and the cumulative effect of those errors, plus the evidence of Mr. Loffler and Ms. Jeglover, gave rise to the tribal issue. And Mr. Kulkov's report, Lordship see an S supplemental bundle, B24, was an incredibly detailed one, and very quickly, bearing in mind the time, if your lordships go to his report at B25, so B24, he says how he's prepared his report. B25 qualifications, he's ex-Freshfields, member of the Moscow Regional Bar, represented clients for 26 years, and what it's worth is in the directories. And then, my lords, he has an executive summary, and the key issues are issues 3 and 4, particularly 3, bottom of B26, whether there were or there are indications of any breaches of natural justice, breaches of human rights, procedural irregularities, substantive irregularities, or an unfair trial in the Russian proceedings and on appeal. And, my lords, at B34, I'm not going to take the lordship through page by page, but at B34 through to B42, he sets out in detail his opinion of substantive irregularities, no proper consideration of issues of causation, and procedural irregularities. Then there are other irregularities he addresses, including that of Mrs. Jeglover at page B47, paragraphs 229 and following. And then happily, my lords, at B60, there's a joint report with, I'm afraid the print is very small because of the photocopying landscape, with Professor Egorov. But if your lordships look at these paragraph, page B80 3, so B80, he sets out, or there is set out rather, sorry, not B80, forgive me, B82, sets out in relation to issue 3 the areas of agreement and disagreement over that issue number 3 between him and Professor Egorov, and that goes to page B89. And then at and the third column sets out the area of disagreement. And then B90 deals with, sorry, issue 4, B90 deals with the relevance of a GPN as well. So the short point from all of that is that there were lots and lots of, there was a swathe of errors, a swathe of matters which couldn't be determined one way or the other at a summary hearing at all. Again, which raised a tribal issue when taken together with Mr. Kulkov and, of course, Jeglover. And it is right, my lords, that at the core bundle, please, at A66, at paragraph 118, the paragraph 118, Judge Burton's judgment, A66. The judge did purport to view the alleged breaches cumulatively. She said, is this a case, a second line, where there are so many alleged breaches that while none may overcome the evidential hurdle in isolation, cumulatively they may come close or meet the threshold test.
I'm definitely looking in the wrong place.
Oh, I'm so sorry,
Lord. Doesn't say that. So which paragraph was it?
Paragraph 118, my lord, in the core bundle. I've got it as
yes, I see.
A66. I'm sorry if
No,
it's...
thank you very much.
And she says no, and she gives two reasons, my lords. The first is Mr. Drelle didn't raise the complaints in the Russian proceedings. Well, again, as a matter of English law, that's irrelevant. I made my submissions on that. And then it said he exhausted all avenues of appeal, and both courts having reviewed and neither he nor his lawyers or expert criticised findings of the Cassation Court or Supreme Court, both courts having reviewed procedural issues. No, there is, in my judgment, no cogent evidence to suggest a general tribal issue. With respect, those answers to those questions she posed herself are non sequiturs and are misconceived for the reasons we give in paragraph 62 of our skeleton argument. And she doesn't answer actually the question she posed. And I've also, and then at paragraph 107, my lord, in the judgment of the judge, Mr. Justice Richards, which we looked at, I think, already, we also, I've commented on that already, but 107, the last sentence, without expressing any views on matters of Russian law at a high level, there were always going to be difficulties in establishing a tribal issue. The judgment on an issue such as this was so fundamentally flawed as to be deliberately wrong. Well, that may be true when you're looking at a judgment of a French court or a US court, but it isn't, with the evidence of Mr. Loff and Mr. Kulkov, correct in relation to this particular judgment. So that's why, my lords, we submit ground 4 is made out in relation to the experts. The lords, had the judge approached the appeal before him correctly, he should have held that there was, at the very least, a tribal issue as to impeachability. That the ICC Judge Burton had gone wrong in rejecting Ms. Zheglova's evidence as to predetermination, whether it was because it was inadmissible or double hearsay. It was immaterial as a matter of English law in the context of impeaching a judgment of fraud, whether there were appeals and what those appeal courts had held. And in any event, given Mr. Loff's evidence, which couldn't be discounted, those appeals weren't going to be conducted fairly anyway. Mr. Loff's evidence was powerful context for Ms. Zheglova's evidence, as was Mr. Kulkov's evidence, and all of that, coupled with the point about GPN driving the case, should have resulted in the dismissal of the petition, of course on the premise that you're against me on ground 1. There was no cross-examination, and what happened was the ICC judge, as I've said before in a different context, did not resist the siren call to dispose of the matter. And that was wrong and unfair. So for those reasons, my lords, we ask you to allow the appeal. Those are my submissions.
Thank you very much. So 10:30 in the morning. All rise, please.